Yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Kraft, and we welcome counsel to this oral argument, which is being live streamed so that we may fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were in the courtroom together. Each of you has 15 minutes, and Mr. Rose has reserved some time for rebuttal, and the clock has been programmed accordingly. Unless there are any announcements, I will ask Ms. Kraft to call the case.
Be Pratik Pandharipande for MD versus FSD Corporation.
Mr. Rose, you have the floor.
Good morning, Your Honor. Ben Rose on behalf of the appellant in this case, Dr. Pandharipande. And this is a case regarding retroactive narrowing of a substantive property right. Here, the right to engage in short-term rentals in a lake resort development called Four Seasons on Center Hill Lake. And I want to start the argument this morning by focusing on the 2018 amendment, because I really think it's the 2018 amendment that gets us to where we are. And it's taken a number of different complexions, if you will, over the time of this litigation as it's developed from the trial court and indeed through this appeal. The first thing I would mention about the 2018 amendment is that it contains a grandfather clause. And before we look at any of the legal arguments, and of course the briefing in this case has been extensive, this case really can be resolved if you look at the language of the grandfather clause, which provides any owner engaged in leasing or subleasing activities as of the date of this amendment shall be allowed to continue leasing or subleasing activities until the expiration of the term of said lease or said lot is sold or conveyed to a third party. Well, it's undisputed that my client, Dr. Pandharipande.
Mr. Rose, let me stop you for a second and ask our IT specialist, Mr. Jacobson. I do not see Judge Golden.
He's there.
Okay.
I'm here.
Very good. That must be my monitor. I was afraid that you had dropped off. All right, thank you. Judge Golden is with us and in person and in spirit, and so Mr. Rose, you may resume.
And I can see him too, Judge, if that matters.
Okay, thank you.
And so I was going to say that the grandfather language of the 2018 amendment should stop the analysis right there. My client, Dr. Pandharipande, was engaged in short-term rentals after he purchased the property, and certainly as of the time the 2018 amendment was passed, he has not, it's undisputed that he's not conveyed or sold the property to a third party. And so the first issue with the amendment is the grandfather provision should apply. Now, if that's not correct,
what lease would that apply to? Was there a long-term lease on the property, or would the rental itself be considered a lease? So at the end of that particular rental, then the grandfather clause would no longer be applicable.
That's a question. That's a good question, Judge Golden, and it's not clear in the amendment. And of course, under the guiding principles, these provisions need to be clear and specific. And if there's ambiguity, that is interpreted against the proponent of the restriction. And here that would be Four Seasons. But that is a good question. Our position would be it addresses leasing activity. And in fact, the leasing activity has continued as of the time that the amendment was enacted. And until such time as he conveys or sells the property, the grandfather provision would control.
But it does say the conclusion of the lease, doesn't it?
I think it's. I'm going back to look. It says any owner engaged in leasing or subleasing activities as of the date of the amendment shall continue until expiration of the term of said lease. That's correct.
And aren't your leases under 30 days?
Well, it depends on, again, it depends on how you interpret leases.
Well, does your client have any individual lease that was for more than 30 days?
No, Your Honor, that's not in the record.
All right, thank you.
So stepping back for a moment, even if that grandfather provision does not control here, Then we go into the legal analysis. And as we briefed extensively, I think the notion that you can retroactively narrow a substantive property right, like the right to engage in short-term rentals, is a pretty novel concept, not only in Tennessee, but also as it relates to other jurisdictions, which we may talk about in a moment. And that's particularly true here. This is not a condo development where it's much more tightly regulated. This is a lake resort on Center Hill Lake with individual properties owned. And there's an interesting history related to how this all got to be up until the 1984 amendments, which were recorded in 2000. But it's a novel issue.
And I've heard you say that before. Why do you say they were recorded in 2000 when the record suggests they were recorded in, I believe, March of 84?
Because that's what the Four Seasons stipulated to, Your Honor, not only in their pleadings, but they also specifically responded to a statement of material fact that provided that the 1984 amendments were not recorded until 2000. And that's what the trial court based its ruling on. If you look at the transcript, the trial court.
I'll look at that again. I read it differently. Thank you.
Yes, Your Honor. So because of that, I reached out to opposing counsel. Obviously, we knew there was a dispute that was brewing, and I asked for authority that would essentially trump the general rule that I just articulated. And Mr. Wigger produced one case and one case only, and that's the unreported condo decision of Devon. And he said that that Four Seasons would stand on that decision, and that's all in the record. Well, we subsequently filed suit, filed a deck action, and then we moved for summary judgment, both on the grandfather language that I just talked about and on the fact that Devon, as a condo case, did not possibly apply to this situation. Devon involves a condominium development in suburban Williamson County, and it doesn't even involve short-term leasing. It involves regular lease arrangements where an owner of a condo wanted to lease her condo out to a third party for financial reasons. And there were problems with that from the beginning in terms of the way the governance worked within the condo development. And then subsequent amendments to that later that were retroactively applied. The trial court found in favor of the Property Owners Association. And that case, of course, came before this court. And Judge Cottrell considered the arguments. And I think interestingly, because of the way that the 2018 amendment has been couched differently after this, Judge Cottrell did not write that other precedent like Tefteller, for example, applied to this situation. What she said was, this is an issue of first impression, and particularly first impression related to condos, not chalets on Center Hill Lake like Dr. Pandharipande's property. And indeed reached out to the other jurisdictions, specifically condo cases like Florida, and found that, in fact, when you live in a condo, as I think we will all agree to, you sign up to a different regimen, if you will, or scheme in terms of what governs the development. Having briefed that issue, we then saw the first turn or the second iteration, if you will, of the 2018 amendment. In further pleading from Four Seasons, Your Honors, we were then told that no, it's not Devon, and it's not retroactive narrowing of a substantive property right. It's actually Tefteller that we're relying upon. And of course, as Your Honors know, Tefteller is a case from 2005, I believe, related to a development company trying to rent multiple chalets and stipulating in that case that, in fact, what they were doing was operating a hotel. Well, Mr. Wigger and I may not agree on many things in this case, but I think we'll all agree that if you stipulate to running a motel in a development where you've got a residential use only provision, that's probably going to be a problem for you. The Tefteller case doesn't apply, but the best perhaps evidence that it doesn't apply to this situation as a secondary or backup argument is in fact the 2018 amendment itself. There's nothing in this record, Your Honors, that would even suggest that, as later explained by Four Seasons, the 2018 amendment was there only to allow long-term rentals. Indeed, the record is replete with references that we are passing this 2018 amendment to prohibit retroactively short-term rentals. That's exactly what it was for. And it was that way until such time as they saw that Devon was not going to be the case that they hoped that it would be, and that they went and ran and clinged on to Tefteller. So the 2018 amendment doesn't make any sense if Tefteller applies. Obviously, if that applies, then all Four Seasons would have to do is say, we're going to enforce the original covenants or whatever covenants that may control, and therefore short-term rentals are prohibited, but maybe long-term rentals are allowed. So Tefteller doesn't apply for the reasons I stated and also other reasons. And then I think the third iteration, Your Honors, of the 2018 amendment that we've seen really came as a result of the briefing in the appeal, and then of course the Mitchell opinion that came down from the Supreme Court. And now we're told in the briefing that in fact the purpose of the 2018 amendment was not to retroactively narrow a substantive property right. It wasn't in fact to allow long-term rentals. What we're told in the briefing, the third iteration after Mitchell of the 2018 amendment, is that it was drafted and enforced indeed to make restrictions less harsh on short-term rentals, that they never existed, and that now this amendment is there to allow some sort of level of short-term rentals. And that's, of course, the argument we made from the beginning. I mean, the general rule with regard to property law in Tennessee in this situation is that you can pass restrictions, and they could make these restrictions prospectively on short-term rentals if they want. What you can't do is you can't retroactively prohibit a substantive property right, like the right to engage in short-term rentals, and put them upon Dr. Pandharipande when he purchased his property with that full right to engage in those rentals. And that was our argument from the beginning. And now we see that, in fact, Four Seasons has agreed with our argument on the precipice of this appeal. I see my time has expired, Your Honor, and I'll yield the floor.
Thank you, Mr. Rose. We'll hear from you again on rebuttal. Mr. Wigger. Be sure to unmute, Mr. Wigger. There we go.
Good morning, Your Honor.
Morning.
I'm Gary Wigger. I represent the Appalachia FSD Corporation. The trial court properly found that the 1984 declaration prohibited the appellant from short-term rental of his property. As Your Honor noted, the 1984 declaration was valid, duly recorded, binding on all FSD owners as of March 29th, 1984. Clearly, it's found.
Why is there a dispute as to its recording?
Your Honor, I have no idea. The
Well,
plaintiff,
Mr. Rose says you stipulated to something or you agreed to it in a pleading.
Your Honor, we don't believe that that is correct. The plaintiffs knew of the 1984 declaration in paragraphs 6 through 10 of the verified complaint. We argued the 1984 declaration throughout the motion for summary judgment. At any rate, under the Orion Federal Credit Union versus Brewer case, State versus Lawson, this court may take judicial notice of matters that are of public record. Article
Is there a
1.
dispute about the date of when it was recorded? As I understood it, he said it was not recorded until 2000, but Mr. Pandharipande purchased the property in November of 2015, so it would have been of record when he purchased it.
Your Honor, that is our position as well. Clearly, they had been in effect for approximately 31 years by the time Dr. Pandharipande took possession of 181.
But do you agree it was not recorded until 2000?
I do not, Your Honor. I do
I
not,
see.
based upon, if you would look at the very last page of the document, it clearly says the foregoing instrument and certificate was noted in book A6, page 983 on September 29th, 1984.
All right, thank you.
Yes, sir. According to that document, Article 1, Section 7 defines a lot. And that says a portion of the property is made subject to the terms and conditions of the declaration and intended for any type of independent ownership and use as a residential single family. Contained within that declaration also is Article 12, Section 1A, the use restriction. That's what we're here about. One of the issues we're here about says, except as otherwise provided in the declaration, each lot shall be used for residential and no other purpose. Article 12, Section 1J, no gainful professional occupation, trade, or other non-residential use shall be permitted on the property. The trial court properly ruled that Shields Mountain property versus Tefteller was the controlling case, not some other case from some other state. The restrictive covenant in that case said all lots shall be used for exclusively. In that case, the defendant rented his cabin through a rental chalet business. He advertised through the website for 2 night minimum stays. He checked guests in, provided keys in a separate office. The defendant provided service at the end of the stay, maid service, trash service. The Tefteller court held that the language, all lots shall be used for residential purposes exclusively, was clear and unambiguous in prohibiting short-term rental. Now, compare that language with the language in Article 12, Section 1A. Each lot shall be used for residential and no other purpose. The plain language of the 1984 declaration mirrors the Tefteller restrictive covenant language. The appellant's use of his property in this case is just like Tefteller. He's been short-term renting since he took the property in 2015. He uses a third-party off-site rental company. 2 night minimum stay. It's advertised on 25 different platforms. Cleaning services provided, trash services provided. Even concierge service is provided. If you want to get chocolate covered strawberries and champagne scent, he'll take care of it. That's in the nature of a hotel use. Based upon all that, the trial court properly held that Tefteller was controlling in this case. The trial court correctly ruled that the appellant could not meet his burden of proof for proving estoppel. In Callahan versus the town of Middleton in 1954, the Supreme Court set out certain elements that needed to be proven. As far as the appellee's conduct goes, was there any conduct amounting to false representation or concealment of material facts? The trial court found no such conduct. The analysis at that point stops. But we could look to the actions of the appellant also under the Callahan. Did the appellant lack knowledge of truth as to the facts in question? The trial court found that the appellant was aware of the 1984 declaration. It could be amended, and that the 2018 amendment was properly promulgated. Did the appellant prejudicially change his position? Absolutely not. Since day one, he's been short-term renting up until today. He has been making money, so he has not prejudicially changed his position at all. At the summary judgment stage, a non-moving party must come forth with specific facts in the record, which must be admissible. in the Scanlon versus McDill versus Columbus Corporation, in the HOA context, the court said community violation must be so general as to frustrate the object of the scheme. Sporadic and distant violations do not in and of themselves furnish adequate evidence of any abandonment. Well, what did the plaintiffs put forth? That there was infractions back in 1990. That's 30 years ago. Clearly a distant violation. The trial court found correctly that there was no credible evidence whatsoever that estoppel was involved. The trial court correctly found that the appellant's use of the property was not merely incidental. In Walker versus Thomas, this court said that whether an incidental use of a restricted residential property in violation of a restrictive covenant depends upon the wording of the restrictive covenants and the use. Justice Rowota in Parks versus Richardson said that a residential purpose only restriction means a property is limited to use for residential as opposed to commercial or other purposes. The appellant stipulated that rental use of the property is not merely incidental in this case, but instead the property is being rented as a business venture. Looking to Carr versus Trevette, the restrictive covenant in that case said that the property could be used for no purpose other than residential purposes. Well, Trevette advertised as a tourist home. 4 of the 8 rooms were rented out to 12 or 15 tourists per week. The Tennessee Supreme Court held that the defendant violated the restrictive covenants. The court distinguished between boarding houses from private residences where occasionally accommodations or guests are accommodated who had not been solicited through advertisement. That's not the case here. Most, if not all, of the appellant's guests were solicited. The trial court correctly found that the appellant's use of the property was not merely incidental. And I will get to Forest Crossing versus Devon in just a second. But insofar as the 2018 amendment is concerned, the trial court correctly held that that amendment restricted the appellant from short-term rental. In 2012, our Supreme Court, Hughes versus New Life Development, held that a homeowner should not be heard to complain when, as anticipated by the recorded declaration of covenants, the association amends the declaration. The purchaser buys not only subject to the express covenants in the declaration, but also subject to the amendment. This brings me to the preserve at Forest Crossing. Counsel opposite argues that Devon is not good law anymore. Judges Clement and Bennett, you both joined in presiding Judge Cottrell's opinion. The holding in that was a properly promulgated, amended restrictive covenant can validly limit or prohibit rentals as long as it's not arbitrary or capricious. Now, Ms. Devon, as well as the appellant here, both argue that Graham is controlling. Well, the fallacy of relying upon Graham is that the court in Graham found that the amendment was not properly passed. The master deed was not complied with. The master deed in Graham said that no amendment may discriminate any owners unless consented to. Well, that was the reasoning behind Graham. Devon is still good law. This case, like Devon, was appropriate for summary judgment because The amendment was consistent with the association's governing documents. The amendment was consistent with the Tennessee Horizontal Property Act, which your honors know that Devon was decided on, not on the Condo Act, but on the Tennessee Horizontal Property Act. The amendment was neither arbitrary nor capricious, and it was properly promulgated. The appellant just doesn't like the result, the vote of the majoritarian association that he freely chose to enter, using language directly from Hughes. Now, dealing with the grandfather, the trial court properly ruled that the appellant could not rely upon grandfathering provision of the 2018 amendment, and it should be affirmed. That decision should be affirmed. Where there is disjunctive or, and only one of the criteria must be met to satisfy a requirement. The conjunctive and means that all must be met. That's under prior Oldsmobile versus Tennessee Motor Vehicle Commission. Judge Golden, you were absolutely correct when you looked directly at this and said, any owner engaged in leasing or subleasing of this amendment shall be allowed to continue leasing or subleasing until the expiration of the term of said lease, or said lot is converted to a third party, conveyed to a third party. As the appellant would like to see, to replace or with and requires the court to completely ignore the ordinary and natural meaning of the 2018 amendment. Appellant's lease ended when his last short-term rental stopped after July 24, 2018. Thank you.
Thank you, Mr. Wegger. Mr. Rose, you have some time for rebuttal.
Thank you, Your Honor. Just a few points, and picking up on what Mr. Wigger just said, there is an or there. It's not an and. And so as I read the grandfather provision, that would include situations where the term of the lease is expired or the lot is sold or conveyed. And it's undisputed that the lot has not been sold or conveyed. Mr. Wigger said during his argument that he has no idea why we would get the notion that the 1984 amendments were not recorded until 2000. Well, I have an idea about how we made that argument. And if you look at page 6 of our reply brief, we specifically asked, as part of the summary judgment practice, a statement of material fact number 4 that says, on or about March of 1984, the then president executed the direct declaration. The 1984 amendments purportedly amended previous restrictive covenants and was recorded over 16 years after its execution with the Register of Deeds. Response from Four Seasons, undisputed. If you look at the record, and that's in the record that we cited there in terms of our brief as well. And again, if you look at the hearing transcript, the trial judge based part of his ruling on the fact that those restrictive covenants were not recorded until 2000. Why does that matter? Well, after the Mitchell case, if that is correct, and that's a judicial admission which Four Seasons has to own because of how they've responded undisputed to the statement of material fact, Four Seasons, if this court considers the previous restrictive covenants from 1967 and 1974, Four Seasons is unregulated. And that's because those covenants expired after 20 years. The latest they could have recorded the 1984 amendments to make them effective would have been 1994. And they have admitted that that didn't happen until 2000. So that's why it makes a difference, to answer Judge Golden's question. Mr. Wigger was reading the court some language from the 1984 amendments, and let's assume that they are effective, and let's further assume that there's a prohibition, even though it's not specifically stated within the restrictive covenants, against short-term rentals because they somehow constitute commercial activity. One thing I was just following along in the reading, and one thing he didn't point out is there's an exception to that provision. It's highlighted on page 15 of our main brief, and it talks about there's a prohibition, and then goes on to the end to say, provided that this restriction shall not apply or shall not prohibit, rather, consultations, conferences, or the transaction of business by telephone or other electronic devices. Well, even if the restrictions apply, that's exactly what Dr. Pandharipande is doing with this model of short-term rentals. And it's in the record that he uses the portal and uses it just like the folks that come and use it like a residence. He personally does that. They all use the portal. It's all keyless entry. It's all electronic. There's no transaction that's there. It's totally different than the hotel that was in Tefteller. But even giving Four Seasons.
Let me ask you a question.
Sure.
I'm not sure I understand this. Mr. Wiggins says the document itself reflects on its face and reflects in the registrar's office that it was recorded on September 29th of 1984. Is that just not correct?
We can't agree with that, Your Honor, because if you look at the technical record, that is a part of the document, and we briefed this thoroughly, that it's an attachment. And so it's not at all conclusive if we ignore the admissions that have already been made by Four Seasons that in fact it was recorded in 1984 and not 2000.
Was there a document that you introduced indicating that in fact it was recorded in 2000?
We introduced the entirety of the document as I recall, Your Honor. And
is there anything indicating a registrar's office stamp reflecting that? I'm just wondering where this 2000 came from. I mean, apparently there's a registrar's stamp that indicates it was recorded on September 29th of 84. Is there also a registrar's stamp on the document that indicates it was not recorded until 2000?
Yes, Your Honor. I think if you look in the record, you will find that, and that's why they admitted to it before they changed their mind. And by the way, the 1984 thing, we have not heard that until the briefing in this appeal.
Mr. Rose, I want to get back to Judge Golden's question. When you set forth a statement of undisputed facts,
yes,
and you state the fact, you are to cite to the record where that fact appears. Where will that fact appear?
I'd be happy to give you that, Your Honor. If you look at volume 2 at page 288 and volume 1 at page 3 and 106, that's how we cited it in the technical record. And specifically the statement of material fact, number 4, there's a specific reference to those facts as well. I believe it was a verified complaint, Your Honor, that we filed that they admitted to that material fact.
Very good. Thank you. We thank both counsel for your arguments, and we will take this matter under advisement. Ms. Kraft?
This Honorable Court of Tennessee is now in recess.
Thank you, counsel. You're